Mr. Chairman, good morning. My name is Joe Howard. Thank you very much for the opportunity to present to you command responsibility and laws of war and hostile UAV operations. Just a couple of housekeeping points. Number one, my presentation alone is being recorded in order that we can put it on the RAUSI website. And no Q&As will be recorded, so we're just going to confine the recording to this presentation. But each of you is more than welcome to visit the RAUSI website, that's wcubed.rausi.ca, and pick it up. It should be posted tomorrow. So with those housekeeping points cleared, I'd like to proceed. We're going to be spanning a period of time from 1945 until 2022. We're transitioning from when command responsibility was first installed and first set up to what I would like to see, or what I'd like to present as the context of UAVs today, namely autonomous weapon systems. So we're spanning the time from 1945, when Admiral Yamashita was convicted in the the Tokyo War Crimes Tribunal of a breach of command responsibility, the normative, to what is now autonomous weapon system, which you might say are drones on steroids. So the presentation today covers 2 points. We're going to cover the normative and look at aspects of the legal doctrine of command responsibility. And as the screen before you sets out, there are 5 issues or 5 aspects that we're going to look at. We're going to define it. We're going to look at where the law comes from. We're looking at the standards. We're going to look at the command of flow responsibility. How does it flow through the chain of command? And we're going to come up with some impacts. Notably, Mark's comments in the earlier presentation referred to the flow of command, and I hope that my one PowerPoint will be able to adequately set that out. The next issue I want to do is sort of christen the ground. And this is the summary of that flow of command and superior responsibility. And this should clarify what it is we're talking about, and equally important, what we're not. So you can read as well as I can, but the flow of command responsibility starts at political and civilian leadership and flows all the way down to item number 4. And item number 4 are the operators of orders. But you will see that point 2 vests command authority in a particular individual. And that is important, as you will see in the next couple of slides, because it is a formalized chain of command with formalized delegation of authority. I'm going to suggest that the political and civilian leadership will also be appointing civilian subordinates, but that level of authority is far less, that's vested in the civilian subordinates, is far less formalized. Notwithstanding, the military commander has got his authority as is sourced from law, and that is national law, which derives from international law. Once the authorities are set up and that the orders are issued, we move to stage 5, hostile operations. And this is where there could be a breach of international humanitarian law in item number 6. And we'll get into the details of what that is, but those are war crimes and crimes against humanity. And I wanted to put this slide out early because it is not the breach of that international humanitarian law that we're concerned about. What we are concerned about is the doctrine in item number 7 of command and superior responsibility. And that is where a superior is accountable for war crimes and crimes against humanity as undertaken, or as committed rather, by subordinates. So when we're talking for the rest of the 15 minutes or so about command responsibility, We're not talking about the substantive crimes of breach of international humanitarian law, such as war crimes and crimes against humanity. We're talking about how the superiors, the commanders and the political civilian superiors are to be held accountable for those breaches committed by their subordinates. The legal doctrine will then be compared to what we call the positive, and we will address what I'm going to call UAV operations. But you will notice, as both Norm and Mark have mentioned, the evolution from unpiloted to autonomously managed. And it's where those gaps in responsibility arise that puts command responsibility at the forefront of the debate. If we're dealing with autonomous weapon systems, drones on steroids, how does that impact command responsibility? And then we'll come up with conclusions. So, definitions. In the background, you'll see Lieutenant William Calley, who was convicted of murder for the My Lai massacre in 1968. There are two aspects to command responsibility. One is military, the other one is civilian. Calley was military. And I'm looking at the Rome Statute Article 28, which defines command responsibility. And it says that the commander, in this case, Captain Medina, who was Calley's superior, knew or ought to have known about the crimes. And secondly, because of the formal chain of command in the military, all activities of subordinates do not have to be proved. The commander is assumed to know about them by virtue of the formal chain of command. The third element is that the commander, whether he knew it or not, but had to have known it by virtue of command, if he failed to take any necessary measures. So he knew or ought to have known, but he didn't do anything. That is the chain of command of command responsibility within the military. The civilian chain of command is different. And we see here a picture of Radovan Karadzic. He was the president of the Republic of Srpska during the Bosnian War. He was a civilian. And his command responsibility is defined just somewhat differently. He knew or consciously disregarded. Remember, the military was knew or ought to have known. But in the civilian world, you either knew or you consciously disregarded. That's one of the two differences between the military and the civilian. The second step in establishing command responsibility in the civilian world is that the crimes were within the effective responsibility and control of the superior. But that requires a determination. Maybe it is, maybe it isn't. Maybe they were within effective responsibility, maybe they weren't. But recall that in the military, it doesn't matter. By virtue of your military appointment, you know, and you're controlled. And then the third step, fail to take necessary and reasonable measures. It's the same as the military. So to compare, on the left-hand side of the screen, knew or ought to have known. But on the right-hand side, you consciously disregarded. Different standards on the second step. All activities automatically fall. But in the civilian world, there is an element of doubt as to whether or not they do fall within the effective responsibility or not. And lastly, no change, you failed to do something. So that is the executive summary of command responsibility in the military world and in the civilian world. And if you recall that flow chart at the very top, we had political leadership, and below that, military officers. So if we are going to talk about command responsibility, we better talk about whether or not it is a legitimate law. So here is a list of treaties and other international instruments where command responsibility originated. Don't look at the names, but look at the dates. 1863 in the Labor Code, which was created during the US Civil War. 1874, following the Crimea War and the US Civil War. And that was the first instrument which really recognized soldiering as a profession. And then the Hague Regulations of 1899, 1907, following the First War, 1919, the Leipzig war crime trials. And on the left, you'll see Major General Stenger, who was convicted in the Leipzig war crime trials, and the Geneva Convention of 1929, which occurred more or less concurrently with the Kellogg-Briand Act, which outlawed war as a means of settling international disputes. In the years following World War II, there were two tribunals which affirmed the existence of command responsibility, Nuremberg and Tokyo. Certainly in Tokyo, the first picture we saw earlier in my presentation, that of General Yamashita, he was found guilty of breach of command responsibility. He had no idea what his troops were doing in the Philippines. He had never given an order for anybody to commit a war crime. He had never condoned an order, and he had no idea of the facts. But if you recall that column under the military, the second item was, by virtue of your military appointment, you do know. So it's, if you will, it's sort of a strict liability that is imposed on military commanders, which is why the chain of command and the formal transfer of command authority is so very, very important. Command responsibility also comes from other sources, notably Security Council Chapter 7 resolutions. And if you look at items 4, 5, 7, and 8, you will see that they arise from SRES 995 and so on, SRES being Security Council resolutions. The point is that the Security Council can, under Chapter 7, set up an ad hoc court. And they did so for Rwanda, Yugoslavia, Sierra Leone, and Lebanon. And the statutes of those courts set out what command responsibility is. So to sum up, command responsibility has got a very legitimate foundation in international law. Just a couple of points to expand on the standards. Yamashita standard was in the context of a friendly force, namely MacArthur, trying an enemy combatant, Yamashita. But after Vietnam, the Cali, Medina, My Lai incident, there was a change, and the Medina standard came into effect, and the Medina standard said, we will prosecute our own officers for breach of command responsibility. So there was an evolution from 1945 to 1971. So to sum up, treaty law has been long-standing, at least since 74, and correct me, I should correct myself, 1863. And it binds the international member states who have signed off on the treaty. And then that treaty law is received into domestic legislation. And Canada will have legislation on its books reflecting the notion of command responsibility. Not only is it treaty law, but it will be found in customary international law. And so there is both an enforcement jurisdiction, which is extant at least within the International Criminal Court, as well within Canada's own national jurisdiction. Just a word on enforcement jurisdiction. The International Criminal Court was set up by the Rome Treaty. The first thing to recognize is that the International Criminal Court operates on the principle of complementarity. Namely, the court will act only if states do not. But otherwise, a member of the Rome Treaty can refer alleged crimes to the criminal court, and so can the Security Council, and so can the court initiate its own investigation. So there's no ground is left uncovered. And I think we've covered that point. So just to sum up, that's where we are. You saw that slide at the start. Item 1 flows all the way through to item 7, but it's item 7 that we are particularly interested in. What triggers breach of command or superior responsibility? So the impacts of this are, the takeaways are that there must be a formalized chain of command. The authority must be vested. There must be a functional reporting mechanism. The military staff must be competent. And that's not always the case, and I'm speculating on the competence of the Russian staff system at the moment. There are rules of engagement that must draw from established treaty law, and there must be training on weapon systems. For the civilian side, there must be similar effective reporting. There must be reporting not only within political leadership, but between political and military leadership. And when we're talking about autonomous weapon systems or drones on steroids, we must also ensure that the procurement system and the design system must understand the technology and its impact on breach of international law. So moving from law to UAVs, the premise is that autonomous UAVs, they complicate the determination of international criminal responsibility, and they do complicate it. There, as you will see in the next couple of slides, there's going to evolve something called responsibility gaps. But does that evolution complicate the determination of command responsibility? Remember, we're talking about command responsibility. We're not talking about breaches of international law. And so the factors to consider in this issue are the autonomy concerning the piloting of the UAV, which is quite different from the command of the larger mission in which the UAV is flown. And we also have to start asking ourselves, what is the role and responsibility of artificial intelligence as an agent of humans? And if there are going to be breaches, what are the standards of proof and what constitutes probative evidence? So I'm going to suggest to you that the legal, and I'm reading, the legal issue of command responsibility as an act of international criminal responsibility does not concern the lawfulness of first strike. We are not talking about the rules of going to war. We're talking about the conduct whilst in war, during war. So if we're going to talk about autonomous weapon systems, what are they? The International Committee of the Red Cross, which is under international law, an authorized agent to promulgate and document international humanitarian law. That was in, I think, Annex 3 of the Third Geneva Convention. The ICRC defines autonomous weapon systems as a system that selects and attacks without human intervention. The US Department of Defense, pretty much the same thing. Human supervised, designed to permit human operators to override, but otherwise the AWS elects and engages without further intervention. So to sum up, the ability to decide engagements derives from, it has to derive from, in part, artificial intelligence. There are a couple of AWSs that are worth noting. Before you, you see the picture called the Cargo Rotary Wing Attacked Drone Loitering Munition System, manufactured in Turkey. It is able to conduct facial recognition, and it has been reported as being deployed in Libya in March 2020. In the background, you will see the unmanned aerial vehicles as an autonomous weapon produced by China. It's produced by a firm called CETC. The video link will be active on the Rausi website, but it looks much similar to an MLRS, where the UAVs are launched with compressed air, wings are unfolded, and then they fly to the target and carry out kamikaze operations. The US Department of Defense identifies AWS as having three different loops, if you will. The weapons can engage targets previously selected by a human. The weapons act independently but are supervised, or the weapons act autonomously. Human Rights Watch, they define or describe AWS loops as human in the loop, on the loop, or out of the loop. In the former, they require human commands. In the middle, there is an oversight function, and out of the loop, the AWS operates solely independently. Noel Sharkey suggests that there's probably a little bit more to the loop debate. Under paragraph 2, the AWS can propose and the human selects, or the AWS selects and the human approves, or that it selects and the human must approve within a limited time, or it selects and attacks and there is no human role whatsoever. But the point between all these three versions of loops is there are responsibility gaps. And it's the question then becomes, where do these responsibility gaps fit within the chain of command responsibility? So overall conclusions, the four principles to be followed in international humanitarian law, and the breaches of these are the breaches which lead to war crimes or crimes against humanity: distinction, necessity, proportionality, and humanity. Distinction between military and civilian, and if it is a military target, does it have to be attacked? And if you do attack it, how much force do you use? And notwithstanding the generality of the foregoing, humanity and preservation of human life is sacrosanct under the rules of international humanitarian law. However, extension of the chain of command between policy and systems does not impact the legal effectiveness of international humanitarian law. But what it does do is introduce programmers and manufacturers into the chain of causality of breach of those laws. But lastly, in the final conclusion, if there's no breach of international law, then there can be no breach of command responsibility. But to answer the very first question, what is the legal connection between command responsibility and autonomous weapon systems? I'm going to suggest to you that autonomous weapon systems do not themselves directly impact the doctrine of command responsibility per se.